All right. Well, as I say, good afternoon and welcome to this introduction to TOLATA. I'm Oliver Newman, going to run through this with my colleague Joanna Gillan. So today we're really talking about what happens when unmarried couples break up. I know that the rest of the family team have been doing a helpful series of talks really dealing with married couples breaking up. What happens when you have unmarried couples? And we're going to go through some of the different tools and different ways that you can bring cases, including Section 2 of the Law Reform Miscellaneous Provisions Act, resulting in constructive trust, so the heart of TOLATA really, but also touching on promissory estoppel as well. So firstly, Section 2 of the Law Reform Miscellaneous Provisions Act. What is it? It's certainly a provision that I think not a lot of people use or are aware of, but it can be very helpful. In short, when you've got an engaged couple and that agreement to get married is terminated, what Section 2 does is that property in which either or both of them had a beneficial interest during the engagement becomes subject to the same rules to determine the rights of husband and wives in equivalent circumstances. So what it does, it pulls in or makes relevant Section 37 of the Matrimonial Proceedings of Property Act. And essentially what it means is that where a spouse contributes in money or money's worth to the improvement of real or personal property in which either party has got a beneficial interest, the contributing spouse acquires a share or an allayed share, a large share of the property. So that means that what the legislation does is that if you're engaged and you break up, as a result of the operation of legislation, not any trust or any other construction, if you've put money into property earned by your spouse-to-be, then you acquire an interest in it, reflecting your financial contribution. So you don't need to worry about strict legal ownership, and you can look at money's worth and equivalent to money's worth. Limitation for this is a little bit different. It's 3 years from when the engagement was terminated. So why use this and not the sort of more standard construction, TOLATA constructions? Well, proving the existence of the entitlement can be much simpler. You just have to show that we've got to prove that there is an agreement to marry, that agreement has been terminated, and a contribution in money or money's worth. So, frankly, the benefits of using this construction are that it should be a bit simpler. You don't have to start going down the different questions that we're about to come on to in terms of trust construction. And so it should be a bit simpler, it should be cheaper to bring, and hopefully a little bit more straightforward in terms of the value. So that, I would suggest, is your first stopping point. If you can prove the engagement, then have a think about what this approach under Section 2 can allow you to do, because it is a bit simpler than using trust law. So before we dive into the practicalities and the ins and outs of different trusts and how you bring it, just what are we talking about and the different trust setup? So firstly, an express trust. Simplest terms of the trust are expressly agreed by the parties in writing, and that then determines the property ownership and the beneficial ownership. So simplest version. Resulting trust, where somebody's made a financial contribution to the property. And mostly here, I should say, we're largely going to be talking about houses because that's largely the property that really matters, but it can be other sorts as well. Shares, I suppose, might be one version. I suppose you could also be talking about cars or something like that can come up. But if you've got an express financial contribution, so you pay towards the purchase price, then that will create a resulting trust, subject to showing that it was a gift or the like. So you need to show that you've made the payment, and you need to show that that payment was not a gift nor was a loan, and that would create a resulting trust. Constructive trusts, and the most common really way that this end up being argued in court, where you've got an agreement, arrangement or understanding or promise between the two parties, can be something express. Somebody says, you know, come and live with me and I'll give you, you know, and pay the mortgage and I'll give you a share in property ownership or something like that, but can also be imputed from the course of dealings between the parties. That gets complicated, and we'll go into that in some more detail in a moment. But lastly, and this is something I'll come back to, is proprietary estoppel, something that sometimes can be overlooked. Essentially, proprietary estoppel, you have to have a promise to act in a particular way, that somebody has acted on to their detriment, and that a failure to allow somebody out of that promise would be unconscionable, would be unfair. And that can be a route that you can either run alongside resulting or constructive trusts, or as an alternative to resulting or constructive trusts. Helps you when, as we run through it, some of the points that you would need to prove for a constructive trust in particular don't bite, or simply as an alternative to a constructive trust. So let's say your client comes in, they say, we've been in a relationship, my partner and I want to bring a claim against their assets. So Jo, what's the starting point? How do you do that?
Thank you, Ollie. Hello, everybody. Before I begin to deal with section 14 of TOLATA, which is what we're going to be looking at, can I say this? I can see that somebody's asked a question. Can I promote that you do that? Hopefully you're all long-standing fans of these seminars and know the drill. But if you want to ask a question, as we go along, type them into the Q&A box and I'll have a look through those towards the end. And I will get back to whoever's asked that question at the end of this talk. And also, I should say, I hope you all are aware that you're muted, so you shouldn't have any concerns about that. We're going to be looking at section 14 applications. These are usually made in the following circumstances: to determine whether jointly owned property should be sold, to quantify the respective beneficial shares that each owner or cohabitee is entitled to, and that's what we're going to be looking at in a little more detail later, to determine whether a party has a beneficial interest in the property, usually where that party's name is not on the legal title and the legal owner is disputing the claim. Again, we're going to look into that into more detail in a moment. A cohabitee whose name is not on the legal title of the property can make a court application under section 14 for an appropriate order to protect its beneficial interest. This would apply where the property is subject to an implied, constructive or resulting trust, as Ollie set out, and the sole legal owner holds it for trust for itself and for the other party as beneficiaries. Lastly, these applications apply to determine whether property subject to a trust of land should be sold. If we could turn to the next page, Ollie, we're going to be looking at who these applications are generally for. So the clients that come to you, where this applies, will be trustees of land or have an interest in property subject to a trust of land. It can apply to other persons, and I've listed those there: a personal representative of a beneficiary, a trustee in bankruptcy of a beneficiary, or a judgment creditor with a charging order over a debtor's share. But we're not going to be looking at those in any great detail in this talk. We're mostly going to be concerned with a client who comes to you, and as Ollie said, a property has been bought either in joint names or in the other party's sole name, and the parties are looking to separate that asset in some way, or one of the parties is, and the other is disputing that they have a share in that asset. And then we're going to look at how we quantify that share and the law, the applicable law. Express declarations of trust. Now, these are super conclusive where they exist. And there is a misconception about what you can do when there is an express declaration of trust. So let's look at that a little bit more. If the parties enter into an express declaration of trust that complies with the requirements of section 53(1) of the Law of Property Act, that is determinative of the party's beneficial interest in the property. And don't be put off by section 53(1). It's relatively straightforward and contains certain considerations like it being written down. It's not a complicated piece of law, and if there is an express declaration that complies with that, it's pretty conclusive. I say pretty because of the last 2 points, or the last point on this slide, which we'll deal with in a moment. At paragraph 10 of the TR1, there is a box which asks the parties whether the property is being held on trust, and if so, in what shares. In Goodman and Gillan, which you'll find on this slide in the second paragraph, you can see, if you want to have some bedtime reading, how applicable this is to situations where you have a client that comes to you, they have an express declaration, they're asking you what they can do with it, how they can change it. That's not what they wanted. Please be careful and read this law in this case before you give any advice on this topic. It is not the case that Stack and Dowden and Jones and Kernot have somehow undermined this fundamental principle. Although those were joint names cases, neither dealt with an express declaration of trust. And in fact, Stack, paragraph 3 here, Baroness Hale said, no one now doubts that such an express declaration of trust is conclusive unless varied by subsequent agreement or affected by proprietary estoppel. It's that paragraph I was referring to. So I say they're pretty conclusive because of those two factors. The second case you're going to want to look at is Panghania and Chandegra, which I can't say very well, 2012, which will also help you with this point of law because it was put to bed in that case. The principles equally applicable to property owned in one person's name with an express declaration of trust between two. So that is also something you want to take into account when you speak to your client. Thank you, Ollie. No express declaration and the property is held in joint names. We're going to be looking at this in a two-stage approach. The first thing you're going to want to consider is ownership and how the property is held and what that means for your client. The second step is to quantify their interest. There is a presumption that equity will follow the law. Therefore, in joint name cases, there is a presumption, the starting point is that each party intended to share the beneficial interest and the responsibilities in the property equally. The presumption can be rebutted. It can be rebutted if the parties had a different common intention at the time they acquired the home, or that they later formed the common intention that their respective shares would change. Again, this is relevant to stage one when you're looking at ownership. In sole name cases, so this is a situation, as we've said on a number of occasions, one that you'll find is quite common if you deal with these matters, when one person comes to you and they want to fight for their beneficial interest in a property that is not held in their name. The presumption still exists. The sole legal owner is the sole beneficial owner. The other party, your client, has to displace that presumption, and it is a difficult burden to establish. It's really important that you get all of the detail in these cases that you can possibly get to make your case as strong as it can be. The claimant must either prove, your client must either prove there was an express common intention that the property was to be shared beneficially, or the court must be able to infer a common intention from the parties' conduct. This is what Ollie was touching upon earlier. Constructive trusts by mortgage payments or purchase payment, but also the party's whole course of conduct in relation to the property must be taken into account in determining their shared intentions as to its ownership. So the law used to deal with very simply mortgage payments and payments on the purchase of the property, but has been developed so that the judge can now take into account all of the conduct through the course of the parties' relationship and their time at the property. What this means again is that you really have to be careful to make sure you get all of the detail of your client's case. Remember that in addition to showing actual or imputed intention, the party must also have acted to their detriment in relation to in reliance on the agreement. So that again is something you're going to have to look at. It's something you mustn't omit from your evidence, from your witness statements, or again your instructions to the client and the instructions that you take. Quantification. What is your beneficial share? If one's case gets over stage one, you've established that part of your case. There is a huge benefit to the party seeking to maximise their interest in the property. The court will consider what is fair, having regard to the whole course of dealing between the parties. The court will attempt to deduce objectively the parties' actual common intention as to the quantification of their beneficial interest from their conduct. Each case turns on its own facts. These are very fact-specific cases. There are varying situations that you can come across. One example is a party that purchased a property together, but in fact one party purchased the property and their name is on the title. And the understanding was it was their property, the other party was going to live in it, but if it was sold, it was theirs. But the common intention changed during the course of their relationship because one party, for example, financed a huge extension on the property, making it much larger and adding value to that property. The common intention therefore changed. And your client, the person who paid for the extension, may well say that they consider that they have an interest in that property. You have to consider why the house was bought, who lived there, what contributions did each party make above and beyond mortgage payments and the initial contribution, what jobs did each party have, and the other assets they own. If it's not possible to work out the share from the evidence, the court can conclude that each party is entitled to the share that the court considers fair, having regard to the whole course of dealing between them in relation to the property. And there's a case there that you should look at. But again, this should ring alarm bells. These cases are, again, fact specific, and the judge will be looking at a whole load of information and potentially coming to a conclusion as to what is fair. A case that you'll also want to look at is Barnes, or sorry, Ollie, on the previous slide, and that deals with where the court imputed intention as to how the property was held. So another little piece of bedtime reading for you.
So we've gone through some of how you sort of bring the case that you're going to look at section 14 if you're looking at trusts. But which approach do you take here? Do you run resulting or constructive or estoppel? And what I should say from the outset is that these aren't sort of you don't have to pick one and not the others. You can run all of these potentially. But certainly in terms of how you're thinking about the case, there are distinctions between the two, and it's worth being aware of them. So resulting trusts, distinct advantage of simplicity. Your share reflects your financial contribution. If you put £20,000 in for the deposit, and that is going to be reflective of the proportion you get out. I mean, looking at property inflation and the value of the property and so forth, but you're going to get in that percentage out again. So it's simpler. It's going to require less evidence. You're just going to need the bank statements or so forth to show that that was what was paid in, along obviously with your witness statements showing that's what it was paid in as a trust rather than as a gift or a loan or anything like that. But it produces greater certainty. It's cheaper to litigate. It's easy to settle because you can say, this is the figure that I'm going for and this is how I reach it. So it's a bit more straightforward. In terms of disadvantages, largely speaking, resulting trusts are now not seen to be appropriate in domestic circumstances. Jones and Kernot looking really at more business approaches where resulting trust is really going to be the appropriate thing. And obviously, you only get out what you put in. If your contribution was partly money and partly other things, you've decorated the property, you've looked after children, anything like that, resulting trust isn't going to give you anything for that. So constructive trusts involve consideration of what would be fair in the context of the relationship as a whole. They'll look at non-financial contributions. So Joe's touched on a few, huge number of things that can come under that heading. But of course, with that comes uncertainty. How much is the court going to value some of these contributions? If you've spent a week decorating the property, how does the court value that? Much harder to prove as a result, because you've also got to overcome whatever the actual property ownership setup is and show that your share should be more than that. And you're going to have to consider the context of the relationship as a whole. So you're going to create far more evidence, much bigger witness statements. It's going to be uncertain, likely for those reasons to be expensive to litigate, and harder to settle, because you may take a view that you're going to punt a bit higher. Your client, the other side, may take a view that you're going to be significantly less of a share. And of course, what it's going to come down to is the court will look at the relationship as a whole and make a judgment call. So much harder to predict and therefore harder to settle. But what happens when you've got a circumstance where resulting or constructive trusts aren't appropriate? So, for example, you've got somebody who's been in stable or protected accommodation. So you've either got local authority, guaranteed local authority accommodation, or you've got long-term rental accommodation where you're not paying a lot of rent for whatever reason, or you've got guaranteed accommodation some other way. I mean, a slightly fanciful example might be you're living with your parents and they've got a big house, and they decide because you're moving out that they're going to move into a much smaller property, so you lose your guaranteed accommodation. You move into somebody's house, there aren't any children, you don't really do any decorating, you might contribute towards general living costs, but you don't do a lot more than that. but you move in because they say, look, you come and live with me, and I'll give you a home for life. It's a sort of common construction. What happens then? You haven't really made a financial contribution. There's nothing really to build a trust off. What you then need to be looking at is proprietary estoppel. Often plead as an alternative to a constructive trust, but also an important point that it can undermine an express trust. So if you've got a situation where you've got a filled out TR1 which says this party gets 10% of the property and this party gets 90% of the property, and actually there is later on an agreement that if you do X, I'll give you a 50% share, then proprietary estoppel is going to be what you're after. So, as I said, there may be circumstances where proprietary estoppel comes to the rescue, where construct and resulting trust won't work. You're going to need a promise that is relied upon to detriment, and where it would be unfair to not enforce that promise. Often, as I say, often plead as an alternative, but it's well worth keeping in mind that you've got these 4 different potential approaches. The section 2, if you're engaged, resulting trusts, which what I would say is now unlikely to be how you'd actually bring a claim, but it's certainly worth thinking about what the outcome would be if the court were to apply a resulting trust. The reason I say that in particular is because in quite a lot of the leading constructive trust cases, although they didn't actually apply a resulting trust, the outcome was very similar as if they had applied a constructive trust outcome. So it's worth bearing in mind that resulting trusts constructions are an easy way for the court to resolve these things, and therefore quite attractive as a solution. So be aware when you're arguing your great wide course of the relationship, etc., arguments of constructive trusts, that it is always quite attractive for the court to come down to, well, who put in what type arguments. So got your client in, you've decided you're running your TOLATA resulting trusts, proprietary estoppel. What are you looking for in terms of evidence? Well, as Joe said, the first point of call is official copies from the land registry. Who is the registered title? Who's the registered owner of this property? Is it in the sole name of the other party? Is it the sole name of your client? Or is it joint ownership? And you need to check the original file in detail, particularly the TR1, TP1. Check, are there any express declarations of trust? Because if there are, and what I say about this is if it's set out that X has a particular share, that is going to be, as Joe says, determinative. If there's no entry in there about trusts, and no entry is that's not necessarily determinative. The fact that your partner is the sole owner and there is nothing on the land registry entry to suggest any kind of division of beneficial ownership doesn't determine the issue. But of course, if you've had a circumstance where the parties have lived together in a house owned by the other partner, that house has been sold and another house has been bought, then you're going to have to ask your clients some fairly pointed questions about why this property remained in the sole ownership of the other partner, because the court's going to want to know the answer to those questions. Be aware that often if you're selling the property and buying another one, you're going to have to sign away the fact that you're going to give vacant possession. So the court is going to be asking questions about why, given you're going to have to run through all this, you'll be aware of it all. Why isn't there a filled out TR1 saying, yes, you've got a share? It's not determinative, but it's important. What about other sources? Well, is there any correspondence from the time of the purchase? Not necessarily between solicitors, but between the parties. Is there anything about intentions? What advice was given? Any agreements or anything dated from that time? Can be useful to obtain a copy of the mortgage application form. Who's on the mortgage? If your client is on the mortgage as somebody jointly liable, then that's going to be very good evidence of a common intention. And equally in terms of finances, contributions to the purchase price. If your party contributed a chunk of money towards the purchase price, you're going to need the bank statements, you're going to need to show where it's from. You may need to look at the source of it. So if it's come from parents, again, are you going to need to get witness statements or information from them that they understood this not to be a gift? That can occasionally be quite a complicated issue, because you can have cases where the parties get together, the parents pay for the deposit, and then the parties break up. Well, the parents may wish to argue that it was a trust, but were they ever planning to ask their daughter to pay it back, or is it really a gift? Can be a bit messy. So you're going to need to think about that in the context of, is it purchased in the sole name of one party, joint names, joint with the express declaration, joint names, but with one greater contribution than the other. Once you've got that kind of root nailed down, you need to start thinking about how else are you putting this. If you're going constructive trust, then what sort of relationship was it? Because you can have cases where somebody's moved in and it is essentially a live-in carer, even if not sort of formally paid. That's likely to suggest, no, it wasn't a common intention to share ownership. But where you've got a romantic relationship being built with children and so forth, that's likely to look quite different. And as you said, what other contributions might there be? Who did the upkeep of the property? Who painted it? How were the finances done within the relationship? Did you keep finances separate, or did you have a joint account? All of these things can pay into this question of, was there this common intention to share the property? Were they sharing their lives together? And if so, what should the split be? I'm just going to pause here to say that it is important in these cases to be careful and realistic about how to pitch them. Constructive trust cases can easily spiral quite fast, with the very extensive witness statements, lots and lots of banking evidence, potentially evidence from other people as to how they saw the relationship if you've got parents involved. So it's quite easy for these cases to spiral into multi-day trials and so forth, and the costs of that are going to be significant. You don't want to be pitching these too high, end up having a very expensive trial on this can be quite nebulous point of, well, how far beyond direct financial contribution do you go, and then lose. So I think it's something to be very careful about. An obvious point perhaps, but just to flag this, that these are cases that are often, if you can catch them early enough before the bad blood's there, very suitable for ADR or mediation or the like, particularly when you've got sort of distinct financial contributions to pass it out and make it a bit easier. And our colleagues, Adam Gersh and Ian Kane, are going to be doing a talk on those topics a bit later next week. So hopefully that has been a sort of rough guide to, firstly, when you've got one of these cases, how do you do it? How do you establish the share? And there's the 4 different ways of section 2, if you're engaged, resulting trust, constructive trust, and proprietary estoppel, and a bit of a guide to how to bring these cases and what to think about when you're doing them. And Jo, I can see we've got a few questions flashing up.
We do. We have a few questions, Ollie, but before I go into those, can I second the issue with costs? Because I think it's a really important point. It's something we haven't done a particular slide on, but it's really important not to be greedy in these cases. You're on the back foot already to some degree if your name isn't on the title or the like, and you should really consider these cases carefully. The other thing that you might want to do is have a look at some of the slides that have been prepared on a previous talk that, in fact, myself and Charlotte Proudman did on Schedule 1 applications, because if there is a child involved and you need some money to house that child, in particular circumstances, there can be some crossovers between TOLATA and Schedule 1 applications, so that when you're talking to your client and taking instructions, that might be something you want to consider as well. There is a question here, but there's a couple of questions that deal with the same issue. So I just want to go right back to basics very quickly and deal with the reality of the situation. The reality of the situation is this: you have 2 people who are in love, who want to start a family together, who have bought a property in whatever way, loans from their parents, one party has sold another asset, has a better job, better pay, put more money in, whatever the circumstances. And it goes into his name or her name because that's who was there at the time. They didn't understand the law. Somebody's father said, just put it in his name. It doesn't matter. They're going to stay together forever. What's yours is mine, and all the rest of the vows. But as we know, that's sometimes not the case. And the 10 years later, the law is there at the beginning on the documents that were signed and sealed at the time of the house purchase. And if it says, again, equity follows the law, that the house is owned, property is owned by this one person, then that's where you begin. That's the starting position. Express declarations of trust, which goes to the questions that have been asked, record at the time of purchase generally what share of the property each party has. That's the easiest way to put it. So it can be that the parties have just come to an agreement picking figures out of the sky, or it could reflect what they've exactly put into the property at the time of purchase. And you wouldn't, one of the questions is quantification, does this apply to an express declaration? It won't, because hopefully that express declaration will be clear, and the law governing how those express declarations should be set out has been followed, and it will show that one party is to get one percentage, the other party is to get the other percentage, and that's it. That's a determination. It's pretty conclusive, as I said, because if you've come to another agreement some years later, sort of a second express declaration, say, well, actually, no, because I did this, I should get a bigger percentage. Well, then that will override the first, or that will be the argument potentially that you'll be having with the other side. But generally speaking, quantification applies where, for example, you've done the extension on the property sometime after it was bought in one person's name with their money, and you're saying, well, I want some share in this. Well, what do I get? Do I get exactly what I put in, which was a £25,000 kitchen, or do I get more than that because actually it's increased the value of the property and I should get a little bit of what I get out of that? I also paid some of the mortgage, and I don't know, I raised the children, painted the bedroom pink. These are the types of things where you'll be looking at quantification, and there is no hard and fast rule sort of at that time. So again, factual information in your evidence is going to be really helpful, and any hard and fast evidence that you can find, as Ollie sets out, is going to be really helpful as well.
So if you've got, sorry, Jo.
No, go ahead.
Express trust, and let's say the express trust says I own 20% and Joe owns 80%, because that's how we contributed. If I later buy a kitchen and install it, I'm not going to get that money back, because the court will say, well, this is what you've signed up to, and that's the understanding as set out in writing, and that's it. And that's what you get out. You know, when you're buying the kitchen, that you're contributing to a property that you're going to get 20% out of. You've agreed to do that, and that's that. The only time that you're going to be able to argue around that really is if Joe comes to me and says, look, if you put in that kitchen and you spend all that money, I'll make sure that when we sell the property, you get that money back. But then you're not looking at constructive trust or resulting trust and quantification like that. You're looking at proprietary estoppel. So that's how you get round express declarations. Otherwise, unless you've got a particular promise that you've relied on that that the property is going to be dealt with a different way, essentially the underlying assumption is that however you deal with the property, whatever contributions you make it knowing that you will still only get 20% and Joe will take 80%. That's why express declarations are so powerful and why it's quite difficult to get around them. But again, what they do is promote certainty. So if you've got properly executed TR1 that sets out expressly how the property is going to be dealt with, everybody should be entitled to rely on that, unless you make a promise that it would be unfair, essentially, for the court to allow you to break. So that's how those two things are a little bit separate.
Ollie, we've got a question here about one of the slides that you dealt with, whether Section 2 of the LRMPA, so that for the latecomers was the law that deals with engaged couples, that's quite niche, where one of the parties is still married, is that law still applicable to their new relationship where they got engaged?
Oh, that's an interesting question. I suppose the argument would be no, because you couldn't actually get married until you were divorced. So I suppose if I was defending it, I would be arguing that the promise to get married couldn't have any effect, and essentially wouldn't be binding until your other divorce had come through, because it wouldn't be possible for you to commit to get married until you were divorced. But I don't know of any specific case law on that. I'm simply guessing as to how that would play out. But that's an interesting question.
I have to say it is an interesting question, and I haven't seen any case law, having looked quite recently, that deals with this. But we are always happy to be told we're wrong. So if it's something that you want more information on, please do email the clerks at the address you can see on your screen, and we can look into that in more detail if you have a particular case that you're dealing with. Ollie, there is another question here. Can you argue different types of trust apply to the parties' intentions to split different properties that they've purchased during their relationship where there's no declaration of trust? So I think that question is asking if there are several properties that these parties own, using that word loosely, during the course of their relationship. Can there be different arrangements applicable to each one?
I think... Again, it's going to be fact specific, but I think the answer is, I would say the answer is yes. Let's say you've got a family home, which is one thing, and you've got a flat bought as an investment. And it is likely that the court would treat, I mean, all of this is fact specific, but if you've got a flat bought as an investment with specific party, one party's put in a certain amount of money toward the deposit, the other party's put in the rest of the money towards the deposit, and you then rented it and used that rental income as, some money to feed the relationship, then I would, my feeling is that would come, the court would be far more likely to see that as a resulting trust. And simply look at that as the quantification of how you've put the asset, how you've put the money in at first. Whereas when it comes to a family home, where the court's looking at how do you manage your money in your relationships, the court's more likely to go into constructive trust. So there's no rule to say that one trust has to rule them all, but equally, you're going to have to show how or why there were distinctly separate agreements about each, because in the end, you're coming down to either express or imputed intention. So you're going to have to show that the parties intended one property to be dealt with in a particularly different way. And this is why I say, I think if you've got one property that's more commercial, that's either been bought for a business or has been bought for particular to raise income or something like that, that's likely to be separate. If you've got your standard family home, you've got a summer home or a holiday cottage or something, I think you're going to find it very difficult to separate the two. But I think there are circumstances where you could quite properly argue that there is a distinct resulting or distinct separate express trust or something in relation to one property, and then argue that there is a constructive trust over the family home and deal with that in different principles. So the answer is yes, but it's going to depend on the circumstances and how everybody's actually holding the different properties and how they're being treated really by the parties. Jo, we're quite a way beyond the half hour now.
Can I say to Sarah, who's emailed with one of her cases, you know who you are. Perhaps if you get in touch with either mine or Ollie's name on the email, you can pick your preference, and we'll hopefully get back to you to help you with your particular case. And also, really quick question, Ollie, where you've lost the conveyancing file or you can't find the express declaration but one exists, well, I'm afraid the court will have to do what they can do with the evidence that you have, unless one of the parties remembers and can provide good evidence that the express declaration said X, you're going to be in difficulty.
You might have a trail that there is an express declaration, because this can happen, that there is evidence of an express declaration, but you don't know what it is. Yeah. I mean, in the end, if you've really got absolutely no evidence as to what the express declaration was, or everyone's just disagreeing about it, you're going to end up likely with the court simply saying, well, we accept that there is a split in ownership and there was an intent to have a split in ownership. But the court's going to have to go down standard trusts construction rules, because if you simply can't say what the express trust was, then it doesn't take you much further than the fact that there was an intention to split ownership. Yeah, unhelpful. And I would be wary of professional negligence claims if another solicitor has lost that relevant part of the conveyancing file, because yeah, puts you in a dangerous position if that's happened, because there's always a risk that someone's going to lose out as a result. But that's like how the court will deal with it in any event.
Ollie, thank you for your time. The last thing to say, because there has been a request for this, are these slides available? Yes, they will be available probably from tomorrow, but you have to give our tech people a little bit of time. They appear under the events tab, I'm told, on the Goldsmith Chambers website. All of the talks are being recorded, and you can, if you so choose to, watch us again at your leisure. I think it takes you to a YouTube link where you can see all of the talks that Goldsmith Chambers have done, and the slides should be there to download. And some of the talks also have a very detailed handout that will be of assistance as well. So if you have any issues obtaining any of those slides, do let us know, but they will be on the website for you to look at your leisure.
Indeed. Well, thank you all for your attention this afternoon, and I hope this has been useful.